everyone, welcome to the video lecture on Seminar 3, the Rule of Law and the Making of ASEAN Instruments. As we saw in the previous two seminars, we transited from ASEAN, a political organization, to ASEAN as a legal organization after the signing and ratification of the Charter. Today, in this video lecture, we're going to examine what the exact parameters of the rule of law in ASEAN as a legal entity, what this means, and also how ASEAN makes the laws as it moves forward in a rules-based environment. So the key themes to keep in mind are, what is the rule of law? Generally, as understood in the international community, and what does the rule of law mean in ASEAN? Does it mean different things, whether in the international order and in ASEAN? And also there is also the concept of the rule of law in the domestic jurisdiction. Is there such a difference between the domestic rule of law and the international rule of law? Apart from the concepts and the definition, and also the substantive parameters, we need to see how we can apply this concept of the rule of law. And if we understand the concept of the rule of law and we need to apply it, what exactly are we going to apply? Do we apply all the features of the rule of law in every situation, or do we apply some features in certain situations and apply other features in other situations? And of course, in the framework of the rule of law, we need to understand what hard law is and also what soft law is, right? So in the first two seminars, we already explored and saw examples of hard law and soft law in ASEAN. Now we look at law, as a concept, as a creature. And so we need to examine, the specific parameters of what hard law is, what the characteristics of soft law are, and are they understood the same in the international community as well as used in the same way in ASEAN, right? We are going to look at the secondary literature by Cohen, Abbott Snydel, and there are three variables. So when you do your readings, please bear in mind that these three variables of obligation, precision, and delegation are very, very important. Also, that whether states choose to sign or draft hard or soft laws depends on their political choices that they make, right? And these political choices may be due to domestic pressures, right? Internal pressures or external pressures. When are we going to look or see, the usage of hard law and soft law in ASEAN? Right? So after exploring the definitions and the usage, we look at the specific examples and usage of hard law and soft law in ASEAN. We look at how ASEAN law is made. What is the form? And does this form correspond to the substance? Right? So, for example, I'm saying that if ASEAN says it has signed a treaty, this is the agreement on XXX. But then when we examine the text of the treaty, does it actually seem to be soft law in the disguise of hard law? Or is it exactly, the substance, the text does correspond to the nomenclature of a treaty? And then, of course, we are going to look at improving lawmaking, both hard and soft law in ASEAN, because, improving lawmaking is a constant process, not only for ASEAN, for all international organizations and the international community, because international instruments have great pressures exerted on them, whether by the members or, or the international climate. So there are very few, if ever, a perfect international treaty or a perfect international soft law. So if there are some obstacles in the way, what can we as drafters do to improve lawmaking? And specifically, we're just going to look at, lawmaking in ASEAN during our Zoom seminar. So, looking at the proper definition, the classical concepts in scholarly literature, we face the question, this big question, a meta question, a kind of a philosophical question of what is the rule of law and why is it always deemed so important in every legal system or society? Why does, basically every country will have a constitution and then they say, all rules must be obeyed. This is, in a way, part of the rule of law, right? So some of the factors in, helping us understand why the rule of law is important in any legal system or any human society is because there is a very close relationship between, making a good law, having a good law, and us as citizens or members of society respecting the law. If the laws are well made, are logical, are fair, are just, then obviously it makes sense that the citizens would respect the law better. The same in the international community. If a treaty or a soft law is well made, is logical, is fair, is just, the chances of greater respect, adherence for these laws would be greater as well. And what is the rule of law? I gave you a kind of a logical understanding, but we will be looking closer at what the jurists, the legal philosophers say regarding the rule of law. So there's actually quite a wide range of definitions, but I've narrowed it down for our classroom to, a few jurists, and we can take the essence, because even if there are differences among legal philosophers, usually the essential characteristics tend to be quite similar. So some of the definitions or characteristics of the rule of law revolve around, limiting sovereign power. So this is at the national level, domestic jurisdictions. There needs to be law so that the government or the sovereign power or people in charge, the people in power, cannot overstep their legal boundaries, their legally delegated powers, and abuse the freedoms and rights of the people. So the rule of law is important in society to protect the average person like us, right? Citizens. And we see this most commonly in constitutional law or public law. There are also notions of justice and morality. As I mentioned before, we obey laws better, or we obey rules better, if these rules or laws are seen to be just, are moral, they help human society, they help us, and therefore are good, right? Or they help us to advance. So there is an element of justice and morality, an aspiration of a better society. And then we look at the international rule of law. So now we look at the more international aspects. We look at Simon Chesterman, yes, the Dean of the NUS Law School. He has written about the international rule of law. And for Chesterman, he says there are three elements, right, for, the international rule of law. There shouldn't be an arbitrary use of power. So, again, no abuse of power, right? And then a good rule of law or a good legal system should be applicable to all, including the leader, the sovereign, those in charge, right? So then there's the rule of law, which could also mean the supremacy of the law. So rules, laws, the rule of law is there. Everybody has to obey it, including the sovereign, the powers, the leaders. And because there is the rule of law, law sets a protective system that ensures that everybody's rights and freedoms are protected. So there is, this equal protection of all, equality before the law, which means that even if a very powerful businessman or a politician infringes on your right, the laws of society, if you litigate before a court, the law will treat us all the same. And even if we're a very small person, a small, poor person, the law, we can litigate and the law protects us. At the international level, there is this rule of law that could apply to, more technical assistance. And the rule of law is very, very important, such that international organizations actually do fund projects. You can refer to this UN project, where the rule of law is inimical and essential to the functioning of human societies. So, there is international aid and international organization programs that help different countries to improve their legal system, improve the rule of law. Now we look at, apart from the practical aspects of the scholastic aspects we have seen, let's look at the more philosophical, juristic aspects. So Lon Fuller is a legal philosopher, and he gives us 8 components of legality. Now, I want to emphasize that Fuller had the domestic legal system in mind, but we can see that his 8 components are very, very important and can also be applied to the rule of law at a regional stage and also the international rule of law. So what does Fuller say? Fuller says that there are 8 components of legality, and for there to be a rule of law, right, the laws need to be expressed in general terms. So they need to be very general, very, as wide-ranging as possible. The second thing is that for the rule of law to flourish, there should be, a wide promulgation of the laws. Wide promulgation means that, the laws, for there to be the rule of law, all laws must be publicly accessible. They must be spread far and wide. Everyone needs to know about these laws, right? Makes sense. If you want there to be a rule of law, how can law rule if one does not understand the law? So if the law is expressed in very specific, very confusing terms, it is very difficult to obey the law, and therefore it would be very difficult to have the rule of law. And if you do not know the law, so there's no public access, no public knowledge about the law, then obviously it is very difficult to obey the law, and therefore it would be very difficult for their society to have the rule of law. And obviously the rule of law is about justice, about fairness. So when one promulgates the law, it needs to have prospective effect, which means that you set the law now, you adopt the law now, and then it applies from now into the future. It must be prospective. It cannot be retroactive. So, you cannot set a law today and say that it applies to, the past 5 years. In that case, we could be in a very difficult situation of penalizing people who may have, violated this new law in the past 5 years, but they didn't know about it, right? If there was no expression, they couldn't know. How can they, look into the future and try to obey the law? So no, if you make a new law, it must apply forward in time and not backward in time. Something about the expressed in general terms, this is a bit repetitive, clear and understandable, can be matched to point 1 in expressed in general terms, and also related to wide promulgation in point 2, right? If you want to have a rule of law, obviously your law needs to be clear and understandable. And clear and understandable means that it also cannot be contradictory. Your law must say what it wants to do. The law cannot say that I want to, move forward or achieve something by a certain date, and then in another provision it says that if there is non-achievement by a certain date, we can remove this law. No, that would be very contradictory. The law must say something and then do what it says. It cannot say that it wants to do A and then goes on to do B. That would be a contradictory law. And obviously the law cannot ask the impossible. If the law is of such a high standard, then nobody can obey the law, and if nobody can obey the law, then there is really no point in asking about or having the rule of law. And of course, for the law to have a proper rule, that it should be constant, it cannot have frequent changes. People must need to know the law. So if it keeps changing, how will everyone know, right? I mean, for example, in this pandemic times, the rules keep changing. I'm not saying that the laws keep changing, but the rules do keep changing, and it's obviously very difficult for us to keep up with the rules, right? But if we were in a certain situation and the law were punitive and the law kept changing, we would not be able to keep up with the frequent changes in law such that we could obey the law for the rule of law to take place. And then lastly, once we have satisfied 1 to 7, the law needs to be administered in a very consistent, just, transparent manner. So, what the law says, the law must do. And the law enforcers must do exactly as the law says. So these 8 components of legality go towards forming a good rule of law. Now, one last thing that I need to mention is that for fullest components of legality, they are mainly procedural. So in terms of, the administration, lawmaking, it's very procedural, but there is justice in procedure. So this is very, very important to bear in mind. Looking now at the international rule of law, bearing in mind what we saw in Fuller, and I also, gave certain examples of how, the Fuller notion of legality or rule of law could apply in certain international contexts. Let's look more closely at the international rule of law. So when we talk about the international rule of law, we would try to understand it as, there is this body of international law, and it applies to govern the relationships between states, because states are international persons, are international actors, or this international rule of law governs relations between states and other international actors. So other international actors could be international organizations, so on and so forth, right? So what are these international actors? I've given some examples. Singapore is a state, so that's an international actor. ASEAN is an international actor because it's an international or a regional organization. So when we look at the international rule of law, or rather a play in the words of the international rule of law, are we looking really at the rule of international law, right? Sometimes when you read the rule of international law, we have the body of international law. And does it mean that for international law to have primacy, to have a rule of international law, this means that international law trumps over domestic law all the time, right? So that's one big question for us to think about. There are certain countries where in their constitutions, there are provisions which say international law is supreme law of the land, right? Which means that even if they have national laws, the international law will transcend, will surpass, will override whatever national law there is. This happens very rarely because generally speaking, states in the domestic jurisdictions do favor domestic law. But it does happen that certain constitutions do put it out there that international law is supreme law of the land, and they take their international treaty obligations very seriously. So that means if a country has already acceded, ratified an international treaty, that treaty has more impact and will override a national law. But this happens only in a few states. In the EU regional regime, because the EU is a supranational organization, EU law is supreme. So it is taken and it acts in that way that EU law will in first instance and in many scenarios trump national law. So even if, let's say, in Italy or France or Germany, they have a certain, economic restriction, but the EU has this law which says that all economic restrictions cannot take effect in the EU. That means that even if France, Italy, and Germany have an economic restriction, the EU law of no economic restriction will trump. That means throughout the EU, there will not be any economic restriction. I'm just saying for an example. And then there is also the global rule of law, where there is this global administrative law school of thought where individuals can work through international organizations without needing to be represented by their country or national institutions. Okay? In certain areas of international law, the global administrative law can work, and we see this a lot in sport law, for those who like football, soccer, and so on and so forth. That's a very good example of global administrative law. Private actors, football stars, football managers, and so on and so forth. You work through your kind of international organization, international private organization, and the state, the national institutions don't have to represent you. But we're not learning about global administrative law in this class, but I'm just giving an example. Okay? So now that we have seen the domestic rule of law, the international rule of law, and even, the rule of international law, we turn now to ASEAN. What does ASEAN mean? Right? ASEAN always says, we want to have the rule of law in ASEAN. So what does ASEAN actually mean by having the rule of law in the region? We looked at this question in the seminar sheet of Seminar 2, right? And we also see that ASEAN has expressly professed the rule of law in the ASEAN Charter, I think in the preamble at Articles 1 and 2. So it all sounds very good. What does it actually mean? So again, we need to go to our very big kind of ASEAN Charter Bible in the EPG report of 2007. And from what we see in the EPG report is that law is to be obeyed, right? We want to have a rule of law. So for law to actually have an effective rule, for law to be effective, all the ASEAN laws must be obeyed. So basically, the EPG said we need to have better compliance, right? But is compliance the be-all and end-all of the ASEAN rule of law? Let's go and explore. Because compliance is very, very important to ASEAN, but we need to see where the parameters are, right? So, going back to the ASEAN rule of law, does ASEAN expect all their laws to be obeyed? According to the EPG report, yes. Because the EPG in their report said, well, before 2007, only 30% of all the ASEAN agreements were complied with. And then, obviously they did not say this explicitly, but in the EPG report, it sounded really bad, like 30, the feeling behind a 30% compliance rate is no good, right? And it's besides the EPG report, there are public statements as well, right? And post 2007 laws, they should be better obeyed. Now, why do we say that, all the laws of ASEAN as a legal creature should be obeyed after the coming into force of the ASEAN Charter? It is not only because the EPG says we need to have better compliance, right? Because the action of ASEAN leaders when they adopted the ASEAN Charter was that we signed the ASEAN Charter, ratify the ASEAN Charter, we have adopt the three blueprints, and we want to achieve so much more in ASEAN, especially in the ASEAN economic pillar. Then to activate and to realize the ASEAN economic community, we adopted so many treaties, so many hard laws across ASEAN, but especially in the ASEAN economic community. Apart from a greater usage of hard law, right? And as we explored in Seminar 2, there's also dispute settlement mechanisms to, try to enforce the treaties. But in the Eminent Persons Group report, they know that ASEAN will continue to adopt many soft laws. And these soft laws have, a wide range of names, such as declarations, like the Bangkok Declaration that established ASEAN, codes of conduct. There are many types of codes of conduct. ASEAN likes to use blueprints for community building. Concords, like Bali Concord, right? Soft laws come in a huge variety of names. So when ASEAN makes these soft laws, it is not the same like in pre-2007 times where, treaty and soft laws are made and then non-compliance. Okay, so if you don't really fulfill your commitment, there's no penalty, nothing happens to you. No, now with the ASEAN Charter, ASEAN as a legal creature, they use more hard laws. They have dispute settlement mechanisms for violations of laws, right? And also that even if we cannot use dispute settlement mechanisms to enforce soft laws, there is a very strong expectation that ASEAN soft laws must be obeyed. I can give you proof, and actually legally binding proof. Go and look at Articles 2.1 and 5 of the Charter. Okay, so compliance is there. They want compliance. But we know that we cannot, we cannot wish for compliance and immediately have compliance, right? Compliance depends on a mesh of several complex issues. First, we need to look at how ASEAN makes laws. What types of laws does ASEAN make? The type of law we make will go towards the level of compliance we can receive for that law. Hard and soft laws, how do we ensure and improve compliance for these laws? And also, we need to look at the quality of these laws, right? Remember in the previous slides when I said the justice, the morality, the goodness, the logic, the fairness of the laws that are made can help those who are under this rule of law to obey these laws better. If it is a lousy law, if it is an unjust, unfair law, the chances are that nobody is going to comply with it. So now we look a bit more into lawmaking, right? The hard and soft law, as we saw in the previous slide. Hard law, treaty at one end, soft law in a spectrum on the other end. Two categories, hard and soft law. Hard law, the classic one is a treaty, a binding treaty. And another name for a treaty can be a charter, so on and so forth, right? Soft laws, as I mentioned just now, have come in a wide variety of names. So what is the definition of hard law? It is as I've already mentioned in the previous videos and previous lessons, that hard laws are legally binding obligations, right? And according to the jurist Chinkin and legal political scientists like Abbott and Sneidel, they say that hard law not only legally binding obligations, but they need to be precise. And not only do they need to be precise, but there must be some sort of governing body or authority to interpret and implement this law, right? So at the international law level, we have this hard law. Yeah, a treaty obligation is legally binding. Treaties in a perfect world are drafted to be very precise. This is not usually the case in daily life, right? Treaties are sometimes not so precise. But the classic understanding and the usual practice is that treaties will tell you, you must do A. Not, you must do A and maybe B, and then if you do C on another day, that would also be okay. No. Usually treaties and good treaty provisions are precise and say, you must do A, right? States must uphold the rule of law, democracy, and human rights. That is very precise. And then for a good hard law, a binding obligation, to make sure that these legally binding rules are obligations, so you need to have a power, you need to have an authority to interpret, resolve disputes or regarding the interpretation of the law, and to make sure that the law is implemented and enforced. For example, the UN Charter, the interpretation can go up to the International Court of Justice, right? Then the implementation, the UN agencies, the member states of the UN, similarly for ASEAN, right? Now let's look at something that is not controversial but has a wider spectrum of instruments. So definition of soft laws are, they're the opposite of treaty. They're not binding, right? So you cannot go to court to litigate a soft law. You cannot go to court to litigate a declaration. So non-binding, but they're still legal arrangements. And the types of soft laws are, well, in practice, as I said, in an ideal world, a treaty would be a treaty and nobody would fight about it. But international lawyers and government international law officers have found that sometimes there can be a controversial category of what is supposed to be a treaty embodying only soft obligations. Okay, so I think you can read this in the Anthony Oust chapter in the book that I've set out for you. And then, but generally speaking, soft laws are, just non-binding legal instruments, or they can be non-binding resolutions, and, this non-bindingness is accepted by all the international persons involved, right? One thing that I need to flag is, are political instruments soft laws? I don't know. I, as a lawyer, would not deem a political instrument, something like a goodwill statement that, for example, there is a declaration of good friendship among UN members. That is a political statement. That is full of rhetoric. That is really, to me as a lawyer, a political instrument. I don't think there is very much law in it, but obviously other international lawyers might think that such a political instrument could actually be deemed a soft law. So depending on your perspective, whether political instruments are soft laws or just political instruments, depends on the outlook you have and also the name and the substance of the instrument itself. Okay, right? Oh, I can give you an example because for Abbott and Snyder, they're political scientists, but they work on legal issues. They do accept political instruments as soft law, but I would disagree with them. Now, why would states want to use hard or soft laws in different situations? The pros and cons of hard law are listed. For hard law, it always seems to be the gold standard, because it is binding. You can go to court to force, a recalcitrant party to obey, so on and so forth, because it's binding. Therefore, it's more credible than a wishy-washy soft law. That's what they say. I don't really buy that, but it could happen. The hard law reduces transactional costs because it's precise, it is binding. So, transactional cost means that since you have already negotiated the treaty obligation, you must do it. So, then there's less transactional cost. But I think people also forget that there are huge transactional costs in adopting, in drafting, agreeing, and then finally adopting, signing, and ratifying a treaty. It may be less transactionally costly to negotiate a soft law that has good commitment levels. So I'm just putting it out there, right? There I come to this point, that hard law has financial costs, there's time costs. Sometimes hard laws are adopted to, as a political strategy, right? And some people say that some political scientists and lawyers have found that if we have a treaty, the member state is more likely to obey this hard law, right? Because they have to adopt it within the national jurisdiction, transformation and cooperation, so on and so forth, right? But this may not always be true because, you have the executive like your president or prime minister who signs a treaty, and then parliament may not want to give this treaty full effect, right? Sometimes there are, neutralizations of, political aspects in a treaty. So once you hammer out a treaty, maybe the issue is less politically sensitive, but again, the data is mixed out there. These are some of the propositions that scholars and practitioners have put out, but I would say that for political strategies, domestic law, neutralization of political disputes through hard law, 50-50 chance, right? But one thing is for sure, weaker states may want to have hard law in the international order more frequently. And why? Right? Because if you have a binding international law, then if bigger states bully you or violate the treaty, the smaller, weaker state can then use that treaty and say, you have violated this treaty obligation and we can sue you, right? So it enhances the leverage and predictability against larger states, especially if the larger state may want to breach the treaty. Soft law, what are the pros and cons? So there's flexibility, as we have mentioned. Soft law, because there's a wide spectrum, it can be very generally worded or very specific, specific to the extent of being almost a treaty, right? Soft law, because it's flexible, states like it because it's less restrictive on sovereignty. Soft law can be a bit more amorphous, so there can be better political and legal compromise, right? Greater flexibility to reach an agreement. There is this myth in public international law where, they say that soft law can evolve into a hard law. That means, if it doesn't matter if we have a soft law now because it will become a hard law in future. I'm very reluctant to say this. This was something that I learned in school, right? And it's classic in all the public law, public international law textbooks. But in my 20 years, I've never seen a soft law really evolving into a hard law that easily. Usually, you obey a set of rules and then finally they decide to hammer out a brand new treaty, right? The problems of international soft law are that, because it's a bit flexible, it's a bit more amorphous, so it's a bit more difficult to enforce and definitely more difficult to interpret, especially in line with domestic laws. And because it's non-binding, some states might want to default on the commitments more easily. Now, knowing the pros and cons of hard and soft law, when does ASEAN choose to use it, right? It depends on circumstances. It depends on the subject matter. Circumstances, for example, if it's a very tense time, remember, let's look at Treaty of Amity and Cooperation. Was it possible to hammer out a Treaty of Amity and Cooperation in 1967 together with the Bangkok Declaration? Probably not, right? So it needed at least 10 years of cooperation to be able to adopt a hard law, adopt a treaty on a sensitive issue of security and stability in the region. All right. Obviously, when states choose to hammer out hard or soft laws depend on the degree of sovereignty involved, right? So what are the national stakes, right? Is there a political and legal culture? So, in the first 40 years of ASEAN, there were fewer treaties, although there were many economic treaties. But now, after 2007, after the ASEAN Charter, we have a stronger legal culture, arguably. I actually believe it, right? Sometimes ASEAN may fall into some path dependency. So they may, due to tradition or usual practice or maybe even inertia, to want to use more hard laws for a certain field and use more soft laws for a certain field, right? So for example, in sociocultural community, is it where, in sociocultural community of ASEAN, where most of the instruments are soft law, is it really because it is so difficult to get a treaty in a sociocultural aspect? Or is it because they are just, more relaxed, path dependent, more used to having sociocultural soft laws than treaties? To using soft laws as primary instrument, but still being executed by a series of soft laws. So, looking at this, could we say that there is a kind of a path of inertia or a usual way of doing things? Maybe, maybe not, right? But it looks arguable that there could be some sort of path dependency or a certain preference that ASEAN. So now we look at lawmaking. What's this definition of a treaty, right? We look at this definition of a treaty. The classic is, and really the international law, the obligation on this is to look at the 1969 Vienna Convention on the Law of Treaties, right? And Article 2 tells us what treaty is, and a treaty needs to be ratified, accepted, approved, acceded, right? Yeah. And then we will use this for our discussion, in-person discussion, in Zoom discussion during the seminar. So there's a huge array of treaties, right? According to the Vienna Convention on Law of Treaties, Article 2, you can make any sort of treaty as long as you fulfill the basic parameters of Article 2. So you can have a formal or informal manner of drafting. So actually the drafting manner does not matter. Only the result matters. The nomenclature, you can have a wide variety. You can call a treaty, or call it an agreement, call it a convention, call it a charter. I put it out as a memorandum of understanding a treaty. Sometimes yes, sometimes no. So nomenclature may not always be indicative of a treaty may not be always indicative of a hard law. If it is amorphous, then we need to look at the actual text, right? So one thing that we're going to discuss in class is how to we identify soft laws and we contrast them with the names of the hard laws, contrast them with the treaties, right? Yeah, so as I said, if we're looking at the MOU, the Memorandum of Understanding, we need to look more closely at the substance. Yeah, so language and substance of treaty making are important. The signature process, the ratification process, and we need to see when it comes into entry into force, and do all treaties need to be deposited? Okay, yeah. The classic rule is that yes, it needs to be deposited, but very often many treaties are not deposited. Let's discuss this. Oops. This AEC blueprint provisions 9 and 13 straddle the hard law and soft law category. I would say that the AEC blueprint is a very firm soft law, very firm. Yeah, so it's very important to fulfill the commitment of the AEC blueprint. Okay, we're going to do this exercise in class. So everybody needs to, we will do this exercise. Just flick your eyes through the materials that I've given, and then we will have an in-class, sort of like game. Okay, so thank you very much, everybody, and see you very soon. Thanks. Bye.